Conditional contracts basically mean contracts that are dependent on certain occurrence or non-occurrence of future uncertain events. There are two types of conditions. The first being a suspensive condition. The performance of a contract is suspended until the occurrence of an uncertain future event that is specified. Once the condition is fulfilled, the effect is retroactive to the time when the contract was entered into. The parties must now perform the contract. If the condition is not fulfilled, the law deems that there was never a binding contract. If no time is specified for the uncertain future event to occur, then the condition will lapse in the event that it does not happen within a reasonable time. An example of a suspensive condition is the popular mortgage bond clause, where the contract is made subject to the purchaser obtaining a loan from a bank or other financial institution for a specific amount, usually the purchase price, within a specified period of time and against security of a first mortgage bond. The second condition is a resolutive condition. The performance of a contract must be carried out and is enforceable until the condition is fulfilled. If the condition is fulfilled, the contract becomes void retrospectively and the parties must be restored to their original possessions to the greatest extent possible. An example would be where the contract is terminated when a license for use of catering an establishment is withdrawn. You can also get a special clause in a contract which includes indemnity clauses, cancellation clauses, acceleration clauses, clauses where the parties agree to a specific address for the service of notices and court documents, arbitration clauses, notice clauses, jurisdiction clauses, and the parties can even agree that the loser of the legal action will pay the winner's entire legal costs, rather than only the limited costs that may be awarded to the court. We briefly touched on rectification, but let us have a closer look at it. As mentioned, rectification is the process whereby a detail in a written agreement can be corrected by agreements between the parties if it does not accurately reflect the intention of the parties. By rectifying the agreement, one does not alter the rights and obligations of the parties in terms of the agreement to be rectified. Rectification, therefore, does not create a new contract, but merely corrects the written document, setting out the terms of the true agreement. We are now having a look at third parties to a contract. You should be able to identify and briefly describe third parties to a contract with the focus on contracts to the benefit of third parties, also known as stipulatio alteri, assignment, cession, and delegation. We'll have a look at these each individually. Stipulatio alteri is essentially a contract for the benefit of a third party. One can think of a life insurance policy, which could be taken out to benefit a third party. Here you have three parties. You have the principal, the agent, and the third party. What will happen is that the two parties to the agreement will agree to keep an offer open for a third party to accept. The third party is not a party to the initial contract, but when they notify the promisor, the one who promises the benefit, the promisee drops out of the picture. The contract is then between the promisor and the third party. If, however, the third party rejects the offer, the contract falls away. It is not necessary for all third parties to be in existence at the time when the promissory and the promisee conclude the contract. For instance, you can create a trust whereby the promisor agrees to devolve his estate to his unborn child. When the child comes into existence and is of an age to accept the benefit, the contract will now exist between the promisor and the then unborn, now born child. Until this happens, in other words, until the third party accepts the benefit, the agreement solely continues between the two parties and can be modified. The promisor may not withdraw from the contract with the promisee unilaterally or do anything that has the effect of preventing performance under the contract. the promisee can obtain a court interdict to prevent the promisor from frustrating the contract. If the promisor breaches the contract, the promisee can claim damages for any loss suffered. Assignment, on the other hand, is when each party to a mutual contract is a debtor and a creditor at the same time. A third party then comes into the picture and acts as a substitute for one of the parties. Consent from all three parties is necessary to take place. Essentially, a whole new agreement is in existence. This is known as novation. Now, cession is interesting. It is a process by means of which one party, the cedant, transfer personal rights to another party, the cessionary. A new obligation is created. Existing rights are transferred from one person to another by agreement. Cession affects the shifting of assets from one estate to another. Upon valid cession, the cedant loses their rights against the debtor, and those rights now vest in the cessionary. A future right may also be ceded. The requirements for valid cession are: 1. The cedant must hold the right being transferred. 2. The right must be capable of being transferred. 3. The parties must intend the right to be transferred to one another. 4. The object of the cession must be properly described. And 5. The cession must be lawful. Another interesting point is that the debtor does not necessarily have to know about the cession or even agree to it. There are, however, some restrictions when it comes to cession. There are common law restrictions, for instance. Wherever the right to be ceded is of such a personal nature that the debtor has a substantial interest in making performance to one person only, for example, contracts of employment, cession cannot take place without the debtor's consent. Furthermore, an action for compensation for harm to an interest of personality, such as defamation, cannot be ceded once litigation has started. There are a couple more which you can find in your textbook under Chapter 2. There can also be restrictions created by the agreement. So where the parties to the agreement agree that the restriction is a term of the contract, the right or obligation cannot be ceded. Let's look at this in depth. Restrictions imposed by agreement become important when the cessionary, to whom rights have been ceded by a cedant, in turn cedes these rights to yet another person. This is known as on-ceding. A cedant who has agreed to an on-cession may limit the security given to the on-cessionary. Can this cessionary on-cede greater rights than the rights he or she obtained initially to secure his or her indebtedness to this other person? In terms of the nemo plus juris rule, a cedant cannot, by means of cession, vest in the cessionary more rights than the cedant itself has against the debtor. Finally, we look at delegation, which has the effect of substituting a third party in the capacity of a debtor, and all three parties' consent is necessary in order to achieve this. In effect, there is a novation to which the creditor, the original debtor, and the proposed debtor must all give their consent.